Good evening. So today's session is about an awareness about the number of cases which have taken place under Posh. Many times I get a question from HR as in how serious is this matter? How seriously we should take this act? Is the law really, considerate about what is happening in an organization, especially when the organization is very small, wherein there are just 10 or 15 employees? Is the law really strict about it? Or, are there any workarounds? So, as a CS and lawyer, I will not suggest to flunk this law. What happens is this is quite a established law now. It came into picture in 2013, and there have been many court cases, right from Supreme Court cases to High Court cases, which clearly establishes that such kind of harassment will not be tolerated in the organizations in India. So today we will discuss 4 or 5 such cases in brief, just to give you an idea that yes, this has been taken seriously by our constitution, by our laws, by our courts, and hence organizations have to be careful about the compliances with these laws. The first case which we should mention under this is the Vishakha versus State of Rajasthan. It happened way back in 1997. This was definitely a landmark judgment because this is where it all started from. As in, not that such things were not happening before 1997, they were definitely happening, but 1997 case, Vishakha case, was something which was kind of an eye opener for people, which was a kind of eye opener for the government, that such cases have to be taken on a serious note. So initially there was it is also called as a Bhavari Devi case, but it is popularly known as Vishakha versus State of Rajasthan. Again, here this was a Supreme Court ruling. So Supreme Court held that sexual harassment at the workplace violates a woman's fundamental right to equality and right to life and liberty. So this was the main judgment which was given, and further to it, in 2000 by 2013 we finally had a Posh Act in place. Apart from that, such cases were continuously happening in the corporate world. They were happening in different workplaces. So another prominent case is Apparel Export Promotion Council versus AK Chopra. Now this happened way back in 1999, and here it was established that employees are liable for sexual harassment by their employer, and that employers are liable for the sexual harassment which is happening to the employees, and that they must take proactive steps to prevent and address sexual harassment in workplace. So in this particular case, the organization had not set up the required committee under Posh, and hence they had faced a lot of repercussions for this. Next is the Internal Complaints Committee of Tata Consultancy Services versus Tanuja Priya Bhatt. So this was a case, again it went to Bombay High Court, and Bombay High Court ruled that the employer must provide a safe working environment free from sexual harassment, and that the employer is responsible for ensuring that ICC is constituted and functions effectively. So around that time, this internal committee was called as a ICC, Internal Complaints Committee. But later on, the word complaints was removed from it because people felt, and the law felt, that it is not a complaint, but it is a genuine concern which is being raised by the employee, and hence the committee name should be Internal Committee and not Internal Complaints Committee. So in this during this time, it was known as ICC, and hence I mentioned ICC to you. The next would be Anjali Bharadwaj versus Union of India, wherein this case dealt with the issue of sexual harassment of women in government departments, and held that government departments must set up ICC, Internal Complaints Committee, to address the complaints of sexual harassment. So broadly, if we see these cases, and in my videos ahead, I would be explaining these cases in detail so that the organizations are aware that yes, law has an eye on them and they have to follow these guidelines. Otherwise, they can be in trouble for any kind of non-compliances. So definitely in the next video, I would be explaining to you about these particular cases. I will be going in the details of these cases. As of now, I am just enumerating the cases which have happened under this. So the next case is Purnima Advani versus Union of India. This case again held that Posh Act applies to government organizations and that the government must ensure that all its offices and workplaces have internal complaints committee in place to address complaints of sexual harassment. So here again, if you notice, the judgment was mainly to establish that yes, ICC is something which is compulsory for an organization and it is a compliance which cannot be done away with. So there are multiple cases which clearly specify that yes, such kind of such kind of compliances are mandatory and they should not be taken on a lighter note. So please do follow me in case you would like to have details about the other case laws which are there. There are many cases which have happened under this act, and definitely it will help you broaden your understanding about the act. Thank you so much for listening. Please do hit follow and subscribe to my channel. Thank you.